Hi friends, governor topic is so much in news. Every year some controversy will happen associated with the governor. So I thought let's cover the topic of governor in a holistic manner. This topic which I am going to cover, it will cover entire topic of governor. What you have to do is only just add whatever the additional current affairs or facts that appear in the newspaper. I have tried to cover everything related to the governor in this short video. See students, governor. Article 153 creates office of the governor. According to this provision, there shall be governor for each state. So this is the major provision that you have to remember. Now from your Lakshmikant, you know the powers and functions of the governor. These powers and functions are identical to the powers of the president. They can simply ask in the mains, discuss simply the powers and functions of the governor. In such cases, you should not lose the marks. So you should be prepared well because governor topic is so much in the news. They can ask simply direct question, powers and functions of the governor. So all of you are aware of these powers, legislative powers. Though all these powers, if you observe, should be taken by the council of the ministers. Government has these powers, right? But all these powers are taken in the name of governor. The legislative powers, he is the one who summons, dissolves and prorogue the state legislative assembly. But in general, it is done by the council of ministers, right? But taken in the name of governor. Summon, dissolve and prorogue the house. He is the one who give assent to the bills. And he also has the ordinance making power, which I have forgot to mention here. Ordinance making power. Just like powers of the president under Article 123. And he is the one who nominates 1/6 of the members of the legislative council. When I say governor has all these powers, it is actually the state government, but generally we take the name of the governor. He lays down various reports in the state legislative assembly. So what are those reports which are laid down in the state legislative assembly? These are important for your prelims. Okay, like say for example, he is the one who lays down annual financial statement in the house, which is nothing but the budget, right? All of you are aware of this thing. So financial powers, any money bill can be introduced in the house only with the prior approval of the governor. He also appoints the state finance commission. Budget provision I already discussed. Then executive provisions, executive powers, all the executive functions of the state government are taken in the name of governor. Like say your appointments, appointment of the CM, council of ministers. Now how these have become controversial, we will discuss. Now appointment of advocate general, chairman and members of the state public service commission. While mind you, removal is done by the president. These chairman and the members of the state public service commission. All these are things that are mentioned in the Lakshmikant. Judicial power, appointment and transfer of the district judges. For the high courts, it is again president. Pardon, reprieve, respite, remit, suspend or commute the punishment. Here pardon does not include for the death. Pardon means completely you are done, you are free of any liability. Okay, so this is not available for the death penalty. Apart from this, these are the regular powers and functions. You should write under these heads: legislative powers, financial powers, executive powers and the judicial powers. Apart from this, there are also special responsibilities for the governor. Okay, under Article 371, development of the backward regions in the Maharashtra. In the same way, there is also Article 371A for the Nagaland, for maintenance of the law and order in the state. In the same way, Article 371B, it is there for the Assam, for administration of the tribal areas. In the same way, there is for 371C for Manipur, 371F for the Sikkim. So these are very basic factual things that you are expected to know and remember. Now come to the discretionary powers. Under discretionary powers can be both explicit, that is directly mentioned in the constitution, and implicit, which are not directly mentioned in the constitution but still they are the discretionary powers. Now this is what becoming the controversy and too much in the news. Unfortunately, not just discretionary powers, even the powers that are mentioned here, that is also becoming controversy. Like recently the appointment of CM. Okay, the governor has dismissed the minister. So can they do that? No, they cannot do that. I have shared the article in the Telegram channel based on this thing, right? So even these powers which should not be the controversial or getting controversial, we'll see this thing. So what are the discretionary powers explicitly mentioned or under Article 239 subclause 2? So Article 239 to 241, it talks about administration of the union territories, right? So under Article 239 subclause 2, the governor of one state can also be appointed as a governor of union territory. If he is appointed as a governor of union territory, then he can act in his discretion. He need not act on aid and advice of the council of ministers. Now under Article 200, he can reserve any bill for the consent of the president. Generally any bill becomes act only when governor gives his assent, but he can reserve the bill for the consent of the president. Now why these provisions are being made? So that to ensure continuity of the administration, so that the state government do not pass such laws which can go against the interest of the entire nation or against the laws of the central government. So this provision has been made. Apart from this, special responsibilities which I have already discussed under these heads, these are the special responsibilities. Then sixth schedule, what should be the amount payable to these autonomous tribal councils will also be decided by the governor under the discretionary powers. So they will ask you discuss the discretionary powers of the governor. If you do not mention all these things, you will lose marks. So by heart these things, it is very important. Then apart from these explicit provisions, what are the implicit discretionary powers? Generally governor has no power in appointment of the CM, okay, but in case when there is hung where no party has got the majority, in that case he has to appoint the CM during the hung assembly. So this has become controversy. How? Even generally when there is no party having the majority, there is some priority. So any party which is having largest number of votes should be first invited to form the government, to go for the floor test, but generally this has been violated most of the times by the governor. So this appointment of the CM has become controversy when there is a hung in the assembly, okay. So veto, this is the veto provision. Veto means there are two powers, suspensive veto and the pocket veto. When any bill comes to the governor, he can just keep silent by not giving any kind of decision on it. Suspension veto means sending back whatever the recommendations given by the government for the reconsideration. Now these are also the discretionary powers. Now these discretionary powers are also become controversial, especially because of the Article 200, okay, or some of the decisions taken by the government are sent back for the reconsideration. Then Article 167, right to information. Right to information in the sense, governor can ask from the government, especially from the CM, so about the affairs of the government. So this is also discretionary power of the governor, which is implicitly mentioned. Sending the adverse report under the Article 356. So governor can send fortnightly reports to the president about the governance of the state government. Now he can send the adverse report. Before my judgment, this provision was hugely misused. Governor used to send the adverse report, and automatically Article 356 state emergency was imposed. Now majority there are various judgments and various provisions have been changed by the Supreme Court to reduce this discretionary power of the governor. Still the issues are becoming controversial. Why there is such controversy? Especially it is because of the appointment and removal provisions of the governor. What is that? Article 155 talks about the appointment of the governor, which is done by the president. Then Article 156 says that he should be appointed for 5 years term, but it can be terminated earlier by resignation by the governor or dismissal by the president. Here he need not mention the grounds, not necessary. Okay, so this is what the major issue. Though he has given the term of 5 years, but appointment and removal is happening at the discretion of the president, and the qualification is only two things: citizen of India and 35 years of age. Because of these things, appointment of the governor has been controversial and removal of the governor has been controversial. So because of this thing, governor is acting as agent of the central government. So he is not acting as independent constitutional machinery. He is a constitutional power, right? He should act like president. He should maintain that kind of dignity, because he is the one who has to preserve, protect and defend the constitution. This is the oath he has taken. He should not act like a person of political party which is present at the center, okay. But because of these two things, appointment and removal, which is happening at the discretion of the president, the major controversies are happening. What kind of controversies are happening? Especially they are happening with respect to Article 200, while appointment of the CM during the hung assembly, and Article 356, where under fortnightly reports, governor is sending adverse reports about the about the state government to the president. Apart from this, the provisions which are not expected to be any kind of controversial are also controversial. That is a major problem. Like say the appointment of members of the legislative councils. This is not at all a discretionary power. He should act on advice of the council of the minister. If he has all those powers, then why there is a need for elected body of CM and council of ministers? Why are we going for the elected body? We are not presidential form of government. We are parliamentary form of government, so we are following the same level at the state government also. But even these provisions are getting misused. Okay, even in Tamil Nadu, governor has been introducing his own words when addressing the first session of the session of the house. Okay, he is not expected to the change whatever the report given by the government, so he has to just simply read the report during addressing the first session of the house. He is changing even this thing. So even the provisions like say someone prorogue, which should not happen at the discretion of the governor, is also happening. So why these things are happening, like I have mentioned, because of the appointment and removal, and also ideology of the particular political party. These governors are carrying some kind of ideology of any particular political party, or they have their own ideology. In general, they should have the values of the constitution values they should abide by. Okay, constitutional ethics, constitutionalism, constitutional principles, that they should follow these things. But they are not following this thing. They are having their own ideology. Because of this ideology the governors have, or generally the people appointed as a governor are generally retired politicians or retired bureaucrats, so they are trying to become loyal to the political ruling party. So because of these reasons, the governor position has become controversial. They can simply discuss the powers or discretionary powers of the governor, and why office of the governor is controversial. You have to mention all these 5 points: appointment and removal of the governor, and discretionary powers which has been getting controversial under these heads, and then even general powers and the activist avatar of the governor under the provisions like say appointment of the appointment of the legislative council in the Maharashtra. These recent examples, like say recent dismissal of the minister in the Tamil Nadu, which I have not mentioned here but have shared article on the Telegram channel. Those recent examples should be given to get the very good marks. Then ideology taken by the governor instead of the constitutional values that governor should have. Then retired politicians or bureaucrats that are being appointed as the governor. Then, so in this case, these are the various issues how the governor position has become controversial. Now, what are the Supreme Court judgment in this context? Now, this can also be the independent question. Article 356, we have seen this is a major area where the position of the governor has become controversial. Now, you have to mention the Bommai judgment, where the discretionary power of the governor has been reduced or has been nullified under the Bommai judgment. You cannot artificially dismiss the legislative council of ministers and the state government without the proper foresight. What generally happens is, governor will say there is a breakdown of constitutional machinery because political party of the state government has lost its majority. There is no floor test, nothing. Generally, state government governor will issue that order saying the state government has lost its majority. But you cannot issue such guidelines. You should first initially go for the floor test. This is what has been given under the Bommai judgment. So no governor can ask for the president rule saying that state government has lost its majority without proper floor test. This floor test has become mandatory. If there is no floor test and even the Article 356 president rule has been imposed, the state government can be reinstated. They can be brought back to the power. Okay, breakdown of the machinery. You cannot simply issue breakdown of machinery. You cannot send a report to the state government by saying there is a provision of the constitution. There is a breakdown of the constitution. For this, you have generally what is to happen is state government on saying that Okay, governor used to say there is a corruption. Okay, state government is not following the principles of secularism. Like this, some simple things they will say, and they will say there is a breakdown of the machinery. Now, under the Bombay judgment, Supreme Court has given certain guidelines. You cannot say there is a breakdown of machinery on simple guidelines like based on corruption and on these charges. And all these things will be under the judicial review. This is what said under the Bombay judgment. Then there is also major judgments under the Shamsher Singh case and the Nabam Rebia case. What this judgment says, under Article 163 there is a provision in which governor says what constitutes to be discretionary power is also the decision of the governor. This was taken as the provision by the governor. Okay, this was vague, actually, Article 163. Okay, so what are the discretionary powers? Okay, so most of the times it was interpreted that those discretionary powers, what are those discretionary powers, is also the discretionary power of the governor. This was the interpretation initially, but later on Supreme Court in the Shamsher Singh case and the Nabam Rebia case said that governor should act only on aid and advice of the government, not governor, on the government. Because why there is a elected head, council of ministers, why there is a CM, this is the body which is expected to rule the state. This is the elected body which is expected to handle the governance, and he should act only on aid and advice of the council of ministers. So this issue was struck down, or else was handled in the case of the Shamsher Singh and Nabam Rebia case. So this is very important provision. And then as governors are being arbitrarily removed, so in BP Singhal case in the 2010, Supreme Court said that governor cannot be removed arbitrarily. He will be reinstated if he is removed arbitrarily. Generally what happens is central government says whenever there is a change of party, okay, let's say now the elections are happening in 2024, if some other party comes to the power, they will change the governor because they feel the present governor is not in sync with the ideology of the central government. So based on those premises, governor cannot be removed because he is an independent constitutional machinery. Why should have the ideology similar to the central government's ideology? So these major issues 1, 2, 3, these are the major issues that were handled by the Supreme Court. They can ask independent question, discuss the role of Supreme Court in handling the discretionary or else controversial issues of the governor. So these things have been handled. So what else that is needed? Appointment, that is the controversy, right? So the Punchi Commission said governor should be eminent person, he should be a detached person, he should be person outside of the state government, outside of that state, he should be the member outside his state. He should not, let's say if it is from the if the person is being chosen as a governor for the Telangana, he should come outside the Telangana. He should not be the person who is belonging to the resident of the Telangana. So, okay, he should come from other state. Okay, he should not be a person active in the politics. So these are some broad provisions given by the Punchi Commission. And Sarkaria Commission said while appointment there should be consultation of the CM. Then there is also a commission called NCRWC. They said appointment of the governor should happen based on the committee system, where the Prime Minister, Home Minister, Speaker of the Lok Sabha, State CM, all of them should participate while recommending who should be the governor. See, if these provisions are implemented, then controversy related to the appointment will be gone, right? And removal should happen like the president. Okay, so if you should and must remember these major recommendations by the Punchi Commission and the Sarkaria Commission. What did Sarkaria Commission said on the removal? Removal should happen only on the compelling reasons. You cannot remove the governor arbitrarily. He should also be given time for the explanation, and those explanations should be properly reviewed by the independent committee. This is what said by the Sarkaria Commission. So definitely remember Sarkaria Commission and Punchi Commission recommendations on the appointment and the removal of the governor. Now let's also discuss why there is a need for the governor. So these things we have discussed. So what are the discretionary powers of the governor? What is the role of Supreme Court? How these discretionary powers can be curtailed using the recommendations of the Punchi and Sarkaria Commission? Then what is the need for the governor? Should the governor position be abolished? So this can be a question. So you have to generate the points. uh, previously there was a position of the governor because of this reason. Okay, there was a problems of the separatism, there was a problems of the regionalism, especially during the times of the independence. During the time of 1947 we have so many such issues, right? So we need governor to preserve, protect the constitution when states display separatist tendencies, and also during the emergencies where no party has got the power and there is a need for central government's role to handle the situation. And also sometimes the state government's machinery is not enough to handle the law and order. What if law and order has been severely affected by issues of, like, say, external aggression, any kind of armed conflict? In such conditions, the role of governor is important to recommend the central government such kind of protection under article 355. You know this provision, right? And also to ensure the continuity in the government, just like we have the president under the parliamentary form of government. To ensure the continuity, similar to the president, there is a governor at the state level to ensure the continuity before one party so that when another party, there are, during the time of elections, right? By the time next party gets into the power, so in the transition, to ensure that continuity properly happen during the transition time, we need a governor. Okay. And then uniformity of administration, we have central level and state level administration, and to maintain the uniformity of that administration, to bring the coordination between the central government and state government in various matters, be it in cooperative federalism, be it in legislative administrative matters. So governor is expected to be a linchpin between the central government and state government. All these things will ensure all these things are is what making the need for the governor. Okay, so should it be abolished? Why it should be abolished? Okay, why it should not be abolished, or why do we need governor? These are the provisions that you will talk about. Then why it should be abolished? Now we don't have such kind of issues of separatism. Now there are so many controversies related to the discretionary power or regular powers of the governor, and conflict between the elected and nominated position. Elected person is the your CM, right? Nominated position is your governor. There is a conflict is present between these two positions. Then it is against the federal provisions. During the time of Government of India Act 1935, British has because they wanted to control the state provinces. No, there is no such provision, right? So there is no such kind of requirement to control the state provinces. The British introduced this provision of governor to control the provinces, but no such need is present now. And powers can also be distributed between the Chief Justice of the High Court and the President. So everything related to the governor I have covered. Why there is a need for governor, should it be abolished, and what are the issues or controversies associated with the governor, what are the various provisions of the Supreme Court. So everything related to the governor has been given. Then what should be the conclusion? Conclusion, you can mention governor position should be reformed. Once governor has been appointed, he should be made ineligible for politics or any role except for the appointment of the president and the vice president. This position should be reformed in terms of the appointments and the removal. I hope you liked the content. I tried to cover entire thing related to the governor. Thank you for watching the video.